Good morning, everyone. Welcome to this very early morning panel. And I'm happy that at least some of us managed to get here so early. And today we all welcome you here to the panel on Internet Architecture and Human Rights here at the Taipei Regional Internet Governance Forum in 2016, where I think all our panelists are really happy to be here. I just quickly want to mention that I'm really grateful to my university. I'm a researcher and postdoc there, that I can be here, and I'm happy because these kind of debates and discussions really engage not only the research, but I guess they also have a chance to have a tangible impact beyond academia. That's why I'm very happy. And so this is a brief agenda, what we're going to do today. And please be aware that everybody is allowed to interfere and raise their hand at any point in time and ask questions of the panelists. So after the very brief info that I am going to give in a few seconds, we're going to have a collection of wonderful speakers that I'll just briefly mention now, and they'll have a chance to present their background and their work in more detail as we go. So I'm very pleased to have Makoto Yokozawa, who's a head professor at the Kyoto University and also Nomura Research Institute. Second, we have Malavika Jayaram of Digital Asia Hub in Hong Kong. We have Adam Peake, who is responsible for ICANN relations with civil society organizations. We have Arti Bhavna from Center for Communication Governance in New Delhi. And we have Arun Mohan Sukumar from Observer Research Foundation, also in New Delhi. And all these people are going to present certain different aspects as they relate to human rights and internet architecture. And once we have all their presentations and points of view, we can have a community discussion, which I'll hope you will enjoy and will join. But once again, please interfere whenever you feel there is a need for that. So without any longer overdue, I just quickly want to say why we think having such panels and perhaps articulating the internet architecture and infrastructural aspects is important, and what is it in the first place. Because perhaps the most important distinction is that the internet architecture does not address internet usage and content as such, but rather it focuses on political and economical implications of design and administration of internet architecture, and various different bodies exert authority over related aspects of internet technical architecture. These include, for example, organizations such as ICANN or IETF. That's why we're happy to have Adam here. And also many of us are actually involved in the work of ICANN. And also these include internet intermediaries such as Google, Facebook, who actually mediate digital rights online. And while this architecture is actually not very visible to the internet users every day, we believe that it affects their access to knowledge and digital rights and the exercise of fundamental rights online in very enormous ways, and that's why we believe it is important to discuss these things. We have a little brief intro what are human rights, but I believe we can skip this, and perhaps it's not necessary at this stage to dig any deeper. I just say that there are actually different categorizations of human rights that perhaps are most relevant to our discussion as it relates to internet architecture, because these are the more complex issues. There is no consensus of, for example, whether economical and social rights should be given the same weight in the context of internet as just first-generation political rights and issues like that. But the core idea of human rights is that they apply to everyone, irrespective of any differences that we might have. And perhaps this is especially important in the context of internet, which is a really global, which it has a really global reach, well, to a certain extent, I guess. And this is absolutely nothing new in a sense that perhaps the idea that our fundamental rights apply online and they should exist on the internet is just based on simple idea of non-discrimination and universality and sort of tech neutrality in that sense, that doesn't matter what we use, we have similar rights, whether we watch TV, we play games in real life, or whether we use internet. So it's nothing new in that sense. And perhaps what is important in this context, because the organizations that I mentioned initially that exert influence on internet architecture, these are mainly private bodies. We don't have treaties governing the use of internet or internet's infrastructure. We have actually private bodies, such as I mentioned previously, IETF, ICANN, Google, Facebook, and so on. And in this context, it's important to say that human rights as such, they apply indirectly to these organizations because they're not governments, they're not states. And their use is actually, in fact, very limited. And that's why I think we face many of the issues that we face today. And in this context, it's important to highlight the Ruggie principles, as they're known, the United Nations Guiding Principles on Business and Human Rights, which I think a lot of work is being done in the context of these various organizations and other initiatives to somehow translate how these principles might apply to these various organizations. So let's talk about these global implications and about internet architecture and human rights. And so I would like to pass on the word now to our first speaker, Makoto Yakozawa, who's a head professor of market and organization informatics systems laboratory at the Graduate School of Informatics at Kyoto University. So I hope that Makoto can present his work in a closer manner himself, and I will now pass on the word to him. Thank you very much.
Well, thank you, Monika, and thank you for all who is joining this panel. Very distinguished guest and a very nice place to talk about the human rights and internet architecture in Taipei, which is my most visited, most familiar city in the world. So I would like to mention about a little bit about the data ownership as a human right. So as Monika has mentioned, this, the combining the two different issues, which is one is human rights and the other is the internet architecture, it is very, very difficult, to be honest. So, well, many meanings and many aspects can exist. So I'm just highlighting and who I am with the who is mois.asia. This is my laboratory's homepage. And you can see, if you can see that my name and my email address can be shown as this who is database. So maybe some other speakers will mention about who is and maybe some privacy issues and the architecture issues here. But just let me say, this is me, okay? So I will be showing some other aspect of the internet architecture, firstly. So, yes. So this may take a little bit time. Okay. No. Oh, this one. Okay. So no. Yes. Well, let me show this animation. This is the country-to-country net migration from 2010 to 2015. So as you can see, I can enlarge a little bit to our region. Okay. So this is our region. And you might have noticed that compared to the, India is a very good linkage to the other region. But compared to the, these Europe, US and Europe, in Asia, in our region, the human transportation or migration is not so significant, all right? But it's okay. We have the right for the moving, okay? We can go wherever we want. So this is basically the human rights. So how about the human rights online? So, okay, so freedom of safe usage of the internet, how is that? So I will show another link here. It's from Kaspersky and the cyber threat real-time map, all right? So a little bit slow here, but you can see this, some bombing. You can see some, the rights just being attacked by someone else. Okay, this is the US. I don't know how to. Okay, but anyway, you can see this a little bit. Japan, here, Taipei, and your country maybe. So we are always being attacked by somebody else and from some other countries. So this is actually a threat in human rights to use freely the internet. So it's a little bit different from the freedom of the transportation or movement. Okay, so this is what we are experiencing right now, and I can show how the internet architecture in the very, very physical, very, very low layers, physical layers of the submarine cables among with our region. So we have a very good link between over the Pacific Ocean and also the South China Sea, and even to the Australia and New Zealand. So this shows we can potentially have a threat from any other country. So how we can protect our human rights online, including the overseas attack or overseas hazard, is very, very essential. So here, this slide shows again the map, a world map. You can see some colors. Green is free in the freedom of the expression. So this link is from the freedomhouse.org and indicating the status of the freedom on the net in 2015. So the green countries are good, and yellow countries have a little bit problem regarding the freedom of the expressions. And the blue is generally okay. So, sorry, it's not the opposite. Sorry, blue has some problem, and green is free. Okay, so this is their evaluation. So it might not be correct, and if you may have some other idea that you should consider some other things, so you can talk with the freehouse.org. But this is the situation. And here we have a very, isolated regulations that hinders the data trade or free flow of information over the seas. So, for example, Japan has renewed our privacy protection law last year. And also the Vietnam, Thailand has a similar data localization, so-called data localization restrictions here. So, and China, Russia, they have their own regulation, and the EU has GDPR, which is a general data protection rules. So this situation is very, very important to think about about the human rights online. Okay. So the next thing I would like to highlight is the data ownership. Ownership is a very good word to highlight who will own your own data. So naturally thinking, it's yourself. but the things are not like that. So in many cases, your internet provider will own your own data. And bank, mobile phone operators, and e-commerce providers, and your government, they can have the opportunity to own your own data, your personal data. So, for example, if you take my photo here in this room, who owns the data? Okay, so natural thinking, the photo was taken by you, you will own the photo. But this is my photo. So my, yours, yours, yours. So that's very complicated matter to protect the human rights regarding the personal data, okay? So, and the other example is the anonymized health record of my disease. If I can utilize my data to develop a new medicine or new healthcare methodology, I will be happy to give this data to the hospital or some research center. So who is the owner in this case? Especially this is anonymized, okay? So it's a very complicated structure in the digital economy about the human rights here, okay? So in that case, we are just discussing about the trustable partner of ownership, which means whom we can trust and give our own data to that body. Who is that? So we have a very good name, data brokers. So government can be the person who can be trustable, or bank, or cloud service providers. Many of you are just giving your own data to Google or Facebook or many service providers. So that means you just trusting. You have the trust. You gave the trust to those providers. Or somebody may want to say no, just yourself. Okay, so in Kyoto University, we are just conducting some research on the data ownership. So, and this is one model, or so I can say that this is an architecture, social architecture of the human rights in some aspect. So everyone has the right to control their own data and the usage of their own data. So here there's a very logistical keyword, that's right to control personal data. And also, if you trust somebody else, here we can assume the right to expect proper protection of personal data. So to your providers or the government or anything. So these two rights, fundamental rights in data protection is one, expect proper protection, and two, just controlling that. So we have many bodies to be concerned in this architecture. So we have to just deepen this thinking to assure the protection of personal data online. Okay, so our survey in 2012 just shows which right is essential to the people. The first one was right to stop using. The second one is right to be forgotten, very famous one, or in other words, right of deletion. And the third one is right to set sharing privileges, and so on. So very few people are aware of this situation. There are many people thinking which right is very important and which is not. So some other effort to raise the trust in internet architecture, on the internet architecture, is the certification mechanism. So the very famous one is CBPR here in our region. So CBPR is proposed by APEC, ECSG, which is Electronic Commerce Steering Group. And now only 4 countries, Japan, Canada, United States, and Mexico, are in the part of this CBPR circle. So all the companies have the opportunity to go have the certification of the CBPR and just show their ability to keep your own data very safe and protected. So I would like to recommend the other countries to be in this circle and make some super architecture over the physical internet architecture. Okay, so that's me. And if you have any question, I'm very happy to answer to that. Okay, thank you very much.
Thank you very much, Makoto. This was fascinating, and I would like to now, introduce Malavika Jairam from Digital Asia Hub. And Malavika would like to speak a bit on the aspects of privacy, identity, and anonymity on an internet architecture and the trade-off between the reliability and accuracy and authentication on the one hand, and safety and user privacy on the other hand. So she perhaps will dig into this deeper once we just go back to our main screen in 1 second. Yes, one second. This will just like that. Please come over.
Kind of exciting that I'm actually being correctly attributed now, because I think with this funny, wonderful IGF system of the text, I think I was previously identified as being from Kyoto, which I'm happy to be from, except it's not true. And I think it's great that I love the irony of it coming up with an identity and authentication talk. Thank you. So I don't actually have slides, which I think is partly to keep myself awake and everyone else awake too. I was just wondering, when you hear privacy, what other words come to your mind? What do you hear when people say privacy? Anyone? Any words? You hear, oh crap? Which is a very valid response. Most people do. What else do people think of when they think privacy? Secrecy, exactly. What else? Personal data, yeah. I'm so happy someone thinks of freedom when they hear privacy. Most people hear secrecy and think you're a terrorist and you have something to hide. Anything else? Dignity. Are you a lawyer? Yeah, see. Most non-lawyers don't associate dignity with it. Anything else? Identity, yeah. What else? Control, yeah. What else? Yeah, great. Anything else? See, we're a self-selecting group. We're thinking of positive aspects of privacy, which is great. Most often what I find is you ask the lawyers and the policy people and all the people who think privacy is a good thing. We think it's agency, it's control, it's anonymity, it's choice, it's ambiguity, it's flexibility. We can be whoever we want. It's self-determination. It's safety, right? Privacy also secures safety, secures human security, as opposed to national security, which everyone is worried about. It's about ownership, which Makoto-san also talked about. It's about personality, like the whole German sort of idea of the right to personality. It's about expression, freedom, rights. And rights is a really big thing, right? Which all of us in this room are accustomed to thinking about. But lay people, non-privacy people, non-lawyers, when we talk privacy, what do they hear? Secrecy? Selfishness? They think it's a really narcissistic personal thing and you're against society, that somehow you're locking down personal information that could benefit society as a whole. They think it's unpatriotic, and it's, I've been called everything from communist to leftist to anachronistic because I'm protecting a value that nobody cares about anymore. Sort of the privacy is dead, get over it brigade. They think you're a complete hedonist, like why would you want to do this? They think it's about insecurity and fear, which, as with certain presidential campaigns we've seen, is a very successful strategy to mobilize populations. It's about terror and anarchy, and it's about being antisocial. And it's also about duties. People don't care about rights so much. It's all about your duty to society without caring about what that society owes back to you and what that social contract looks like. So I think for me, like if there was one sentence that I could eliminate from my life, it's if you have nothing to hide, you have nothing to fear, right? Like if someone gave me $1 for every time I've had to defend that or explain that, I wouldn't be at this IGF. I'd be on an island somewhere that I would own, right? That's how often I get asked that. And legal theorists have had a really hard time actually conceptualizing this and fighting back with this. And lawyers are not good at fighting these kinds of arguments, right? They come up with everything from Socrates to Plato to Roman law to, UN principles that don't have resonance for a lot of people in their daily lives. But Edward Snowden actually said what I think is the sort of sharpest, simplest response to this argument, non-argument in my sense, which I think brings out some of the things that I mentioned earlier in terms of those keywords. He said, saying you don't care about privacy because you have nothing to hide is like saying you don't care about free speech because you have nothing to say. And I think that brings about how privacy is actually a collective value. It's sort of saying, oh, just because you have nothing to say doesn't mean you want to prevent everybody else from exercising their freedom of speech. And similarly saying, oh, I have nothing to hide. Well, good, great for you. You probably don't have a life and you should leave the building more often. But if you have nothing to hide, maybe somebody else does. And it's not sinister, it's not scary. Maybe the thing they have to hide is something that they haven't quite thought through. Maybe they haven't thought about their sexuality, about their religion. Maybe they're exploring different ideas, which is why one of the concepts that I really love in the privacy field is something that the author Neil Richards talks about, which is this idea of intellectual privacy, about saying, we talk about temporal, spatial, and different kinds of privacy, informational privacy, but I love this idea of, which he frames as intellectual privacy as the right that if you didn't have anonymity in particular transactions, if you didn't have the right to surf the web anonymously, for example, you wouldn't think of ideas, you wouldn't explore things, you wouldn't develop your personality. And again, it comes back to, that right to personality idea of saying that you would never fully develop as a person if you were too scared that every single search was linked back to you. I might research the jihad because I want to understand it, not because I want to carry it out. But that might mark me as a terrorist every time I go online every now and then. I might be on a no-fly list. It might have very practical concerns just because I'm curious about the world around me. And I think if we don't protect privacy and anonymity online, and I think Aarti will talk more about the threats to the WHOIS system, or rather the threats that it can pose to anonymity. And I think in that context, one of the things I wanted to highlight is where these threats come from also matters. If there was a move to say, oh, all data should be made completely public and we shouldn't allow proxy services and masking services, everything on WHOIS should be absolutely accurate and you shouldn't allow anyone to have, different identities, that would be great if the proposal came from security researchers and identity theft people and people that I actually trusted about this. When it comes from Hollywood and the entertainment industry and it's all about enforcing copyright protections and takedowns, I have to wonder at their motives, right? So I think when a proposal is cobbled together by an alliance that has, the infamy of having worked on SOPA and PIPA and other kinds of very repressive and restrictive pieces of legislation, I would take it with a pinch of salt. So I think Aarti will talk more about that, so I won't sort of hijack that. But I think what I wanted to bring back was this idea of whether identity and anonymity are inbuilt into internet architecture, whether they're a bolt-on, whether it's something we even see as valuable, and the role of privacy-enhancing technologies, the role of privacy by design, and the idea that it's something that you bake into systems and that you make part of the design of a system such that it's not an afterthought that doesn't work well. It's not something that you think, oh yeah, it's kind of like this wonderful sweatshirt that I saw at at the Newseum in Washington, D.C., which is a museum about news, which was great. It had this, in big, large, friendly letters, it had freedom. And then on the side, in a little thought bubble, it said, is there an app for that? And I think that's what all of us want. We want to be able to just press a button and sort of miraculously make everything sort of free and, easy. Nobody wants to actually learn how to use PGP. Nobody wants to use Tor. Nobody actually wants to do a lot of these things that will protect privacy and anonymity, but, requires a little doing from users. And it was interesting that in a breakout session that I had recently at a conference, people were asked to go away and think about what the most serious threats to internet freedom were, where they came from. And people, came up with different responses. Governments, companies, private corporations that data mine. I'm not going to name names here. And again, I'm not naming names because it'll be on the internet, right? And it'll live on forever and ever. Maybe if this was a closed session with things not being recorded, I might have been more candid. So again, it's sort of how much do we self-censor and how much do we sort of think about the things we say living on forever and ever, even though they're half-baked thoughts. But one of the things that came out of that breakout session, which I found really interesting, was one group came back saying the biggest threat to internet freedom is users. And everyone said, wait, there's a little bit of cognitive dissonance there. Don't you mean like everybody else except the users? Like the users are the good guys here. They're not the bad guys who are, posing threats to internet freedom. And people, and this was a bunch of engineers who came back saying users are the worst, right? Because we design all these wonderful utopian things that will work beautifully in like some kind of, utopian dream in a vacuum where real people don't live. But then these bloody users, they just don't use the tools we give them, or they don't choose their settings, or they do really stupid things. And like, we have to keep changing the tech to suit their idiocy, right? So they came and said like, users are the worst. But then all the sort of social scientists in the room and all the interaction designer people were going, so maybe that just means you didn't architect it properly, you didn't engineer or design or code it properly. If you see users as the threat, if you're saying they're the problem and not the solution, go back to the drawing board and re-engineer things, because it shouldn't be that hard, right? If users need to exert that much energy on protecting their privacy, then something is fundamentally broken. So I think that was something I wanted to highlight as well. And it was also about, when we're talking about human rights online, I think this is sort of more from a civil society advocacy point of view rather than a legal one, which is I think we really need to reframe the debate. When we're talking about it as a sort of security issue, as a national security issue, as it versus, identifiability, when we associate that with trust, when we somehow assume that identity is the only pathway to trust, we're losing out on a whole bunch of alternatives there, which have really great potential. And I think that poses a lot of risks on users. It also makes individuals responsible. Like, they're the weakest people in the chain here, yet they're somehow expected to manifest superpowers and actually protect identity, reputation, and trust online. They're also supposed to sacrifice all of these in order, to fulfill some sort of nebulous idea of what societal security looks like. So one of the things I wanted to say is reframe the debate, right? Have it on your own terms. Have it as a conversation. Talk about the things you want to talk about, not just being responsive. And what we really need to do is to make privacy and security completely ubiquitous and banal. If Tor is a problem, if nobody is using Tor, then the 6 people using Tor are going to be looked at as weird people. You run an exit node, oh my God, you're a threat model, right? If everybody is using Tor, it's so banal, it's so uninteresting that it's just the way life is, right? So the fact is, like, unless everyone is using security and privacy enhancing tools, it makes the ones who are using it targets. So I think that's something that I would love to see change. And I think the other thing is to make privacy really cool, right? Because fundamentally, this is all about social norms, norms that reflect societal values and collective values. And if we keep thinking of privacy and hearing secrecy, we're going to lose this battle. The second you want to change the social norms, you have to make it really cool and say, it's really unhip to not be secure. It's really unhip to not think about privacy. It's sort of in the same way when cell phones first came about, everyone was so happy to be yelling into their big fat Motorola bricks, Michael Douglas on Wall Street kind of thing. It was fine. It wasn't considered rude. You were showing off. Now, if you're sort of chattering on your phone all day long, your date is going to walk out on you. Right? So I think that's changed. Social norms have changed around that. And it's also like Gillian York and Jacob Applebaum gave a great talk at the Kiosk Computer Club at the CCC Congress, where they talked about thinking of encryption as the kind of protection you would use when you had sex, thinking of it as condoms. Would you have safe sex? Well, duh, of course you would. Why wouldn't you be safe online in exactly the same way? And I think when you reframe it in using these kinds of metaphors that people actually understand, rather than just talking about, human rights as some abstract thing that the UN once cared about and doesn't anymore, or doesn't really do very much about, or that people just ignore it and get on with their lives, because companies actually frame and manage this discourse now, or governments do. I think if we sort of go back to taking back privacy and security and like reframing it, that would be great. So those were just some opening remarks, because Monika is giving me like the timeout sign, which as a football lover, I understand. Thanks.
I would like to thank Malavika for this inspiring and stimulating contribution. And I think it makes a very perfect sequence on our panel now to have Adam Peake, who is responsible for the civil society engagement within ICANN, and I guess will now introduce sort of a more practical way to actually care for these things that Malavika just talked about, to one of the ways to perhaps find your way to contribute to the technical aspects of internet governance and how we could all perhaps make a small difference with our work. So I pass now the word to Adam, who will talk more on these things and how we all could get engaged and why does it matter. So go ahead, Adam. Maybe you can just get it down.
Yes, where do I go from here? I go there. No, I don't go there. Yeah, if you can go for the beginning, not the Internet of Things. Oh, can I just use the buttons to go forward? Okay, down button. I think it's all right. Good morning. Thank you very much, Monika. Right. Good morning, everyone. Thank you very much, Monika. Yes, I'll try and talk a little bit about some of the work that's going on in ICANN that is generally related to human rights, and really it's about asking for participation. ICANN talks a lot about bottom-up processes, and the notion of a bottom-up process is that someone like myself as staff does not make policy. You hopefully will get involved and find things interesting and want to contribute because it's your expertise that makes policy in ICANN, and that's the purpose of this, or the purpose of how we go about policy making and the development of policy in ICANN. The slide we have here, I think most of you, and I hope all of you, have heard about the IANA transition and the various elements that are part of that. One of them was about enhancing ICANN's accountability. There were two aspects to this. You can see the first, it's a little bit squiggly, if that's a reasonable word. Slightly, not as clear as it should be. Workstream 1 was a set of accountability mechanisms that would make ICANN accountable to the global community once the US government had stepped away. It was the idea that the United States government has historically played a sort of backstop role. If something went wrong, if ICANN did something completely and utterly crazy, like spent all its money on buying yachts or planes or too much champagne, then the United States government would be there as an adult supervisory body and prevent it from going crazy. And so we have accountability mechanisms which now hold the ICANN community and board accountable to the global internet community. And this is going forward. These are being implemented. They're about powers that allow the community to, for example, in extreme situations, remove the board, or to have a reconsideration of how budgets are decided. That's ongoing and is being implemented. There's a second part to this, which is called Workstream 2, which were not deemed necessary for the transition itself, but added important aspects of accountability. And you can see the beginnings of those, of what those issues are at the bottom of that slide. And there's a more detailed list here. And these are the ones that I really want to talk about because some of them are very directly related to, I think, rights issues. At the stop these are the things that we're going to be working on in this notion of workstream 2. This is a process that is starting now. Each of those items with bullet points are now established as working groups that are community-led, and you can join, and if there are issues that you are particularly interested in or have expertise in, then they're the sort of thing that we would like you to contribute to. So the first one is to think about how to improve ICANN standards of diversity. We've had discussions about this here at the meeting already in Taipei. These are issues about how do we improve language services, how do we ensure that people from a minority or different communities can participate more easily. Are the tools that ICANN uses and the community uses appropriate? So there'll be an examination of that, and if that interests you, then you can participate. More relevant, I think, in terms of how we think about rights, is how to enhance ICANN's transparency. It's quite a transparent organization at the moment. We use a lot of scribing, as you can see here. Every meeting that's held online will be at least given an MP3 recording. There's usually notes. There are very often transcripts and so on. So most of the information and how working groups develop have an enormous amount of information about them. The whole process is available to you to follow. But there are ways that we want to enhance transparency, and particularly those are around formal document disclosure policies. There is a document disclosure policy at the moment, and there are some researchers from the region, particularly from India, who are looking into that, doing some very good academic work on how to improve our document disclosure. And so that's an ongoing piece of work that enhancing transparency is really about. There's also how to improve staff accountability. How are we acting in ways that should be more accountable? The accountability of the supporting organizations and advisory committees. Those are the groups that actually work to develop policies. So how are those then made more accountable? And there's a working group and a review process for that. Jurisdictional issues. ICANN is a US-based organization. There's not an anticipation that ICANN's location will move, but there are ways that we can look at how things can be improved, particularly around contracting and disputes. I'll leave the second one and go to the bottom, which is to the enhancements to the Ombudsman's role and function. So this is a way of bringing complaints into ICANN and alternative dispute resolution. Again, if these are the sorts of issues that interest you, then there are working groups that we would hope you will join and bring that expertise and improve. Going back to the bullet second from bottom, it's developing a framework of interpretation for ICANN's human rights commitment and proposed draft bylaw. There's a draft bylaw commitment already, or there is a draft bylaw, sorry, that commits to ICANN providing greater assurance that we will follow human rights in the bylaws. And there's a working group starting up now which will work for about 1 year to look at these issues. Could you bring up the PDF file? So there's a document that's online that describes the work that's ongoing. And I can scroll down. Can I scroll? No. Yeah. So the importance of this is that it won't be a commitment for ICANN to follow the whole gamut of human rights as defined by the United Nations. It's going to be a commitment that occurs within the bylaws. And I don't know if that is particularly readable, but the notion is that there will be, within the scope and mission and core values of ICANN, ICANN will respect internationally recognized human rights as required by applicable law. There are some caveats there. There's ways of not over-committing to the whole range of human rights. But the reason I wanted to mention this is that if you, as human rights activists, are interested in this and want to see how a internet critical internet resource organization, which ICANN is considering human rights and how it should consider human rights, then you have an opportunity now to bring your knowledge and expertise into this particular model. ICANN is committed to this as something that we should and will do. And I think that the notion, again, at the bottom of the page is to consider specific human rights conventions and other instruments, if any, that should be used by ICANN in interpreting and implementing human rights. So it's an ongoing commitment to enhancing accountability, a commitment to responding to the interests and needs of the global internet community. And the opportunity really is that as human rights experts, as I know that many of you are in the room, then there's an opportunity for you to bring your expertise and to help ICANN improve. And that's really the call that I have today, and why I wanted to speak today, is to ask you to participate in this process, whether it's in the particular working group on human rights, or to go back to, and I don't know how to do that, I'm sorry, this is one of the more unusual computers that I've seen. Is it that one? No, it's not that one. Yeah. Or to go back to this whole range of workstream 2 topics, and these are all the working groups that are ongoing at the moment. So the one that I particularly mentioned, of course, is about human rights. But if you're interested in transparency and the rights that are around that, then please think about getting involved. If you're interested in jurisdictional issues, then those are issues that we'd like you to get involved with. And there's also diversity and the other topics there. But particularly for this audience, then it's human rights. And I can give you information after about how to participate, and we can put this online. So thank you very much, and I hope we will see many of you participating in this exercise. Thank you.
Thank you very much, Adam, for this detailed and extensive presentation. And now, just to perhaps stimulate issues a bit more, we will have Arti Bhavna from the Center for Communications Governance in New Delhi in India, where she works as a research fellow with a particular focus on ICANN and particular, I guess Arti is now having her Zoom on WS policy, and I think this is going to articulate more what Malavika was talking about previously and combine a bit of Adam's invitation, and perhaps we'll reveal how exactly these issues are played out on policy level and in very technical setting, and how it actually has enormous impact on our everyday life. So I don't want to occupy any more space and give the floor to Arti.
Thank you, Monika. Hi, everybody. I'll be speaking about one particular part of the Internet architecture policy that has a very direct and very, frankly, at times scary effect on human rights. But before that, let's just look at what. Okay, so Adam spoke about ICANN and the various human rights work that's going on at ICANN. So I'll just take it one step further and look at what the non-commercials are doing at ICANN. So the non-commercials work through mainly the non-commercial stakeholder group and the non-commercial users constituency, the NCUC within it. It consists of basically anyone who's interested in issues pertaining to non-governmental organizations, activists, researchers, academics, and end users. The NCUC pushes for human rights. So if there are people, the human rights experts who are working in this area who are interested in issues of privacy and free speech, this is a great place to be looking at. The Cross-Community Working Party looks at two main things, one of which is the framework of interpretation for human rights bylaw, as Adam just mentioned, and the other is how ICANN's various policies about internet architecture has an effect on human rights. And it is this one in particular that I will be talking about. That's the WHOIS policy. There are a lot of changes going on right now with WHOIS, but there's a lot of reforms going on. But I think before we can begin that conversation, we need to understand what are all the problems with the current one, because there are a lot of changes going on right now and in the upcoming years. So right now, if a person wants to register a domain, if an individual wants to register a domain name, they need to provide certain amount of personal information. This includes their name, their postal address, their email ID, phone numbers, fax numbers, and all of this is required, is a necessity in order to register a domain name. This data is all open and is publicly available to absolutely anybody in the world. And before going into what the problems, I'll just tell you what exactly the policy is. There are certain privacy and proxy services whereby a person does, where their data can be hidden, where under a privacy service, for example, there will be an intermediary that redirects the information. They show you alternative information, alternative contact information, and under the proxy service, there is an intermediary who can be contacted instead of the individual who has registered the domain name. So there are services to mask the true identity of the individual domain registrant. However, a lot of times these services are a paid one, so it's not equally accessible to everybody. And right now there is a proposal being considered at ICANN whereby commercial websites, whereby proxy and privacy services would not be available for commercial websites. Now the problem with this arises in case of small entrepreneurs or people who are starting businesses from their homes, where there is not much separation between the corporate identity and the personal identity. The WHOIS policy exists mainly for, I mean, there are a list of 8-9 purposes, but very broadly it can be categorized as 3. To contact the individual domain registrant in case there are any technical issues, in case there are intellectual property concerns and the lawyers need to get in touch with the registrant, or if there are law enforcement concerns. So if we just look at what all the human right implications are, we are going to consider whether or not whether the human right violations are justified in light of the purposes that this policy is aiming to serve. So first of all, and the biggest one that everyone always talks about when talking about the WHOIS policy, is the right to privacy. The right to privacy as enshrined in the UDHR, the ICCPR, that is a well-recognized right. The United Nations has declared that rights that are protected offline must be equally protected online as well. So just because there isn't a specific right that says that you have the right to privacy on the internet does not mean that all the rights that apply offline aren't available to you on the internet as well. A big problem with relating to privacy and WHOIS is that an individual is forced to give away their right to privacy in this setting, because unless they provide all this information and unless they sign the waiver, they're not registered, they're not given the domain name at all. So there's a huge problem of forced consent in this issue. But to look at very clearly, is the privacy violation, is it justified or not? Let's just look at the necessary and proportionate test, very simply to see whether what ICANN is doing or what the implications of the WHOIS policy are, whether it is necessary and proportionate to the aims that it proposes to serve. I would say not at all, for 4 main reasons. First of all, if the main aim of WHOIS policy is to be able to contact the individual, then there is absolutely no need to have so many forms, so many different contact details. One avenue of contact would be enough, and it would be more logistical to even follow up and to make sure that it is an accurate contact detail that you have, as opposed to having 5-6 contact details of every single individual registrant. Second, and also actually going back to that, is the idea behind being able to contact a person is to contact them in a timely and efficient manner. So it makes absolutely no sense to have the postal address of a person. So because that makes them contactable in the real world, which makes it extremely dangerous, as I'll get to a little later. The second thing is the problem with data retention, because the WHOIS data is stored not only for the period of the agreement, but also 2 years after, which raises a lot of data retention and data protection problems, because it does not justify why a person's personal data needs to be kept for 2 years after the contract is ended, especially given the aims that the policy is trying to serve. Then there is a problem of lack of accuracy. It's not feasible to be able to validate all the data that exists, because let's take India for example. Like I can't see a single way in which you can actually go down and check that all the data that is being provided by the millions and billions of people who are using the internet, or who have, or the many people who have registered a domain. I can't see any way in which you can actually go and verify that that data is accurate. So it raises the question that if you can't even provide accurate information, then what is the point of having the policy? Because the few people who are providing accurate information are getting targeted at the end. And the last problem is the effect that this has on other rights. It has quite a chilling effect. The lack of privacy has an effect on various other rights, which makes you think that this is not quite a proportionate effect that's coming out of the policy. So for one, there is the right to security of a person. You have the right not to be harassed in the real world. You have a right to not be targeted. But the problem is that when you taking the example of a dissident in an authoritarian regime, if they have a website and they're trying and they're communicating their thoughts, they're criticizing the government, the majority, and they're trying to build activism around this issue, they become if you can contact them in the real world, if you can pinpoint their home address, their telephone number, they become extremely vulnerable to targets, to being targeted for various attacks. Not only from governments, but also from members of public, because female domain owners, members of the LGBT community, non-white domain owners particularly, are extremely vulnerable to attacks in the real world. Because once the person becomes contactable in reality, it leaves them open to a lot of attacks. For example, there's a thing called doxing, whereby a person gets personal information of an individual and then disseminates it to the world at large. So with the Who Is policy, if you can get the information of a person, and you're making it even easier for them to be contacted and harassed in the real world. Then there's the freedom of expression, which is frankly scary to see the chilling effect that the loss of right to privacy can have on your freedom of expression. Because if you know that you're going to be targeted, if you know that there's a possibility of like I mentioned, the harassment that can occur, then you automatically clamp down, you self-censor, you do not say the things that you would normally say. And Malvika has raised those points in a really good way in the previous presentation. So the problem is that you're basically having a chilling effect on speech that challenges the status quo, the majority, and the government. And similarly, there's the effect on the freedom of assembly and association as well, because of you can't gather people around to do anything or for any political or social cause, because there's always the threat. As I said before, that there is a lot that's going on right now with Who Is. There's at present a working group on trying to see all the problems that exist in Who Is, and whether it needs to be replaced with a new system, and if it does, then what needs to be there in the new system. So that's the first point. That's the next generation GTLE registration directory service, which is quite a mouthful, but it's called the new Who Is, or the next gen Who Is. This is an open working group, and they're always looking for people, particularly with interest and expertise in human rights, because Who is often criticized for a lot of things, human rights being one of them, but there isn't enough research, or there isn't enough talk about these human rights in detail. So we desperately need people who know what they're talking about, who know about the details about human rights. And there is also, there's currently a new technical system available called the RDAP, which can offer the possibility of differentiated access whereby law enforcement can have different access, or authenticated users can have different access as compared to just any random person on the internet who decides to go onto Whois and check for someone. But the problem is that this is just a technical improvement. There is still a lot that needs to be done at the policy level. So through the issues that I've raised right now, I'm hoping that we can have more conversations about it, that more people can get involved, because with the PDP working group, there is an excellent opportunity to remedy all of these problems that I've currently highlighted. So if you have any questions, very happy to answer it. Thank you.
Thank you very much, Aarti, for this wonderful and fascinating presentation. Now let's move on to our final speaker, Arun Mohan Sukumar, which many of you perhaps do know because he's elected vice chair of Asia Pacific Internet Governance Forum. Arun also heads Observer Research Foundation Cybersecurity and Internet Governance Initiative, and he would like to talk and perhaps finish our panel with talking about United Kingdom and United States of America data sharing deals and how they affect human rights online, and what are the implications and what we perhaps should be aware of. So I pass the word now to Arun, and later on we can have the discussion and the questions to the panelists.
Thanks, Monika. Hi, everyone. My name is Arun. I was thinking perhaps I could spend a few minutes on, as Monika said, not just the UK-US data sharing agreement, but also this this thing called MLATS, the Mutual Legal Assistance Treaty process, which has found its way into the APrIGF synthesis document as well. And there was some debate about it yesterday. The MLAT process is something that I feel fundamentally interferes, or perhaps has some impact on internet architecture or human rights, of course, in a significant way. So as things stand, and with very few exceptions, data flows in the world today are from the east to the west. And like I said, barring a few exceptions, say in Southeast Asia and of course in China, data is not localized. It is largely unregulated data flows. Of course, there are exceptions. And as a result, you have vast amounts of data that are flowing from countries in the Eastern Hemisphere to the Western Hemisphere, which is where most of the big companies today are located: Facebook, Google, Twitter, and so on. What has happened as a result of this data flow is that governments, especially in the Asia Pacific, feel, whether legitimately or not is another question, feel that their law enforcement needs have been somewhat obstructed by their lack of access to data, because the data is all located in countries like the United States, Ireland, or in other European Union countries. Now, there is some comfort to be had in having your data stored in the United States or the European Union, because the judicial and the political thresholds that are required to access data in the Western Hemisphere is much higher than in most Eastern countries. But I think this is not, this is not an entirely accurate statement. Snowden definitely picked some holes in the fact that the United States is being scrupulous with the data that it has access to. And more importantly, I think as an individual, I am not entirely comfortable with the fact that my data flows are somehow being managed by international relations, by my country's relationship with the United States or the European Union, which gives it preferential or non-preferential access to data. More importantly, I think many governments in the Asia Pacific today feel that by virtue of their lack of access to data localization or backdoors to encryption is one policy that they should pursue. If companies are not, and it is a fact that companies are not providing data in response to a government request. For instance, there was some research done on the number of requests that was received and complied with by Facebook from the Indian government in 2013. The Indian government made roughly around 10,000 requests to Facebook for content, which content and metadata, 50% of which was complied with. But if you look at the compliance rate with the United States government made nearly twice the number of requests, roughly twice the number of requests with a compliance rate of 80%. Now, as a result of this, what is perceived as non-compliance by Facebook or Twitter or Google or any of the big companies, I think there is this regulatory impulse that we're seeing in many countries across the world for data localization. And data localization doesn't really help anyone's case. It doesn't help the case of the companies, especially if you are localizing data in countries where it is not safe physically and digitally to locate data, and it certainly doesn't help the case of users in even in democratic regimes. The second, of course, is backdoors to encryption, on which there is an ongoing debate, and I'm sure most of you have plugged into this. One of the ways in which this, some people and some governments see as a way out is the MLAT process, the Mutual Legal Assistance Treaty process. It is a method by which one government provides information to another government on request. It is a purely intergovernmental process, but it avoids the hassle of getting tangled into issues like data localization and regulatory impulses and encryption. In my own conversations with cybersecurity regulators in India, whether whether one takes them on their word or not is another question. But there seems to be the sentiment that if you do get access to data for legitimate law enforcement purposes, then their impulse or their compulsion to seek backdoors or to localize data will be less. So this is seen by some as a way out of some of the more rather intractable questions on localization. Now, the MLAT process itself has a lot of problems. Some of it has to do with the lack of capacity. I'm going to bore you with some details, but there is, so if you take the example of the United States, which hosts a significant amount of data of other countries, there is the Department of Justice, which is supposed to be the agency that provides data to another government on request. Because under US law right now, no company can provide content. And this is not so with metadata, but no company can provide content to, say, the government of India, Pakistan, or Malaysia, wherever it is. It has to be provided first to the US government, which will then provide it to the government, which will then provide it to the requesting government. The problem is that the Department of Justice in the United States government is severely understaffed. On an average, an MLAT request takes roughly around a year, 14 months to be complied with. So, there is some, you can sympathize with the government which is pursuing a cybercrime or some sort of criminal investigation, but it takes roughly a year or more or less, roughly 8 to 10 months, an optimistic assessment, to get that data. So it does in certain cases legitimately hinder law enforcement needs. Given the capacity problems, one way that the UK-US data sharing model provides is by amending this legal restriction in the United States to provide the data first to the US government and then to the requesting government. According to some of the legislative amendments that have been tabled in the US Congress, which will be introduced in the US Congress right now, and this has potential implications for pretty much every country that is represented in this room. Data may now be provided by the company directly to the requesting government. Now, this obviously requires a lot of conversation first, not just with the requesting government, but also, it requires us to be plugged into the laborious process that is the US legislative scheme. And so, I just wanted to, use a couple of minutes to briefly touch upon this, and then we can have maybe a couple of minutes of questions. The UK-US sharing agreement requires certain amendments in US legislation, like I said, which will allow companies to give data directly to governments. What the US government or the US Attorney General's office has tried to do in this process to ensure that there are some safeguards, because it's not just the UK that will get benefit out of this process, but pretty much any country in the world that signs an MLAT agreement or a data sharing agreement with the United States, is that it has imposed a certain number of safeguards which require the country to have reasonable protections for privacy, data protection, and certain sort of judicial and executive safeguards on surveillance. Respect for applicable, quote unquote, applicable international human rights convention. If you've signed the Budapest Convention on cybercrime, that is a plus. Intelligence agencies are out of the purview of this data sharing agreement. And whatever request that you as a foreign government are making to the to the US or European Union company, it has to be something that has the backing of a court order. It is something that should be judicially possible to judicially review it in your home courts. But there are nevertheless a lot of problems with this process because again, the MLAT process is not just a strictly legal process. There is the real danger that the United States might sign similar agreements with countries that have very poor executive or judicial safeguards and may waive some of the legislative requirements. The UK is a whole different, I mean, the UK and the US legal standards on freedom of expression are not exactly the same, but they could be said to be comparable. This is not true of many of the governments or many of the countries in East Asia or in South Asia, for instance. So the real concern is whether the data sharing agreement will result in a process where globally you see data protection standards lowered, but on the flip side, there is the possibility that it might reduce the compulsion of governments to localize data or to seek encryption or backdoors into encryption. So I'll stop there, and then maybe if we have time for questions.
Thank you very much, Arun, for these insights. And now perhaps I would like to invite questions from the audience, and then we could go ahead. So if you have a question that you're addressing a particular panelist, please just point to that person or or say the name. If not, then we can perhaps just see who would be the most suitable. So please go ahead.
Okay. This question I'm pointing to Mr. Makoto. Okay, what you think about the current, okay, so companies have adopted standards for data protection. So I'm talking about HIPAA for health data, and of course the big one is PCI DSS for the critical system, which already have provision for data ownership and protection in the clause. Okay, despite the fact that PCI DSS is pretty fucked up, no offense, it kind of push responsibility to user, but our standard is there. So what you think about data protection between countries will impact this law? Thanks.
Well, and if I understand your question correctly, and you're talking about HIPAA and the other registration concept, maybe. So, well, Arun just highlighted some of the answers to you, and EU is based on the privacy protection as a human rights. So that's a fundamental concept of their legislation, and the US is not. Yes, of course they have in their constitution we have all the people has the rights to be protected by anything. So and the further complex situation in the US is there is many laws legislation. You talked about HIPAA, and we have the some other legislation for the other sectors, like the financial sector, as the Bradley law, and the some state laws like California. So the basic situation and the architecture, I could say that it's a non-physical architecture, and of the internet is that it's very complicated. So so I just highlighted the certification mechanism, and I know in India you have the DPF by the Data Protection, Data Security Council in India, that's DSCI. So in Japan I have a privacy mark system. So maybe we can highlight not in the legislation layer, but some certification or the self-regulation layer. We could assume a very good collaboration and very good harmonization in this layers. So that could answer to your question, maybe some opportunity for us. Thanks.
Thank you very much, Makoto. There we have another question. Maybe we could pass on. Yep. Thank you so much.
Yes, I would like to address the two speakers who spoke on privacy. I wanted just to mention that within the IGF, there's actually a working group which was founded in the IGF in Bali and continued in Istanbul on privacy as innovation. And I think that's quite an interesting and relevant group. Unfortunately, this working group does not have members from Asia, which is also quite interesting in a way. But if you Google privacy as innovation, you can find it's quite a good working group, and you can also find all the documents related to that group. And then some sharing from the European IGF, where privacy is of course the topic. There is some interesting ideas coming out of Finland. They have created a new model called mydata.org. And that's basically a new model, a new operating model on how they call it human-centric model of privacy data. And basically it changes the relationship, how individuals relate to intermediaries, but also to any other companies or organizations that process private data. And I think it is not yet adopted in Europe, but I think some countries are adopting it, like in Scandinavia. So it's quite interesting to look at this model that is used. And third point, I think for Asia, I think it's quite interesting to see what happens in the current discourse on digital money. So I think that will be a very good opportunity to discuss privacy, because there are a lot of people who think it's cool to pay digitally, but there's also a lot of privacy risks which are very often not discussed a lot. Yeah. Thanks.
Thank you very much for highlighting these interesting points. Whether any of the panelists would like to comment on that, perhaps?
That's really useful, thank you. I think what was also relevant, which is also why I was talking about reframing, is I think if you talk about it as human rights, in a lot of countries you just have no traction at all, because people think, if you look at a sort of Maslow's hierarchy of human rights, when people don't have food, security, shelter, privacy falls like very, very low down that chain. So I think if you sort of push it as a human rights agenda, it doesn't always work in some countries, because you often have resistance saying, oh, Indians don't care about privacy, Chinese people don't care about privacy. And there's now very good research coming out about what those notions of privacy might look like and why they might be similar and different. Like recently I reviewed a paper about the whole idea of privacy in China deriving from the idea of saving face, and how it's actually very inbuilt into the culture, and it's not some weird Western value that was imported. So I think there is a lot of really good research on that, but I completely agree that inserting it into discussions about financial systems and economy is really useful. And I just moved to Hong Kong from Harvard, and I find that putting it into a blockchain discussion is like a great way to discuss privacy and anonymity in terms of something that is seen as an enabling technology rather than something scary and awful. So I think that really helps. And I think there are a lot of really good initiatives. Helen Nissenbaum, who's done really good work both as a cryptographer and a philosopher who looks at privacy, she's done work on contextual integrity, but she's also done really, really interesting work on, she made a very good point to me in a class that I took with her, where she said, people keep talking about a marketplace for data. And of course, there's a very flourishing marketplace for data, but we need to change the conversation to one about a marketplace for privacy, where privacy tools and technologies and services are actually competing with each other and doing really well. And I think post-Snowden, we've seen a lot of that getting developed. So yes, I think putting it back in, again, with the business and human rights agenda, I think that's a good framing.
Thank you very much. We can take perhaps another question from the audience. Thank you so much. And then Makoto also wanted to comment on something if we have time. Okay, please go ahead.
My question is about, in certain jurisdictions such as the United States and the Philippines, there's this concept of reasonable expectation of privacy, wherein there will be an analysis of the context of a particular situation to determine whether there could be state intrusion without a warrant. And in my country, the Philippines, the courts have already started to apply that doctrine to the internet, and to rather negative effect. Such as, for example, there have been hints that there can be no reasonable expectation of privacy on the internet just because an ISP will have could see your activity. And in another case, they said that on Facebook, the only way that you can have a reasonable expectation of privacy is if your posts are set to me only or me only settings. I'm just curious, right now, how conscious are designers of software platforms are of this doctrine? Does it come to their consciousness at all?
Take this on.
Well, I would just combine this question to yours about the my data and the financial services. And well, it's a very good question that how conscious the service providers are right now. As well, yes, that's a very complex situation, and if it is based in Europe, they have to comply with the very strong legislation, and the fear if they violate some of the regulation is very high, and about the Google suitcase and the other Facebook's case. So we are just about to learn, how important that data protection is, and that's lead to the question about the payment system. Yes, and you just mentioned the blockchain or this Bitcoin payment issues. That's the ideal if I think about the anonymity in the payment, but it's a little bit too early for us, for everyone to go into that payment system. So now we have the intermediate system like the PayPal or Alipay or some other new, we call it fintech. So, and in fintech services, we have to give our personal data to those service providers. So, including our own name and the bank account number and the phone number, address, everything. Because there is some other issues related to the money cleansing. So, this is very complicated. So many requirements from the many aspects, just fighting each other on the internet architecture, on the higher level of the internet architecture. That's the situation, I think. Thank you.
To be on, yeah. I think that's why the kinds of cases that are happening in the US about the third-party doctrine are really, really important for the rest of the world, because if you're familiar with it, the idea that once your data has been shared with one company, then you lose the right to what happens to it afterwards. And as we all know, you might consent to that initial transaction, but it's the sort of knock-on effect of it then being shared without your consent or knowledge, and the impossibility of you managing those onward data flows when you don't even know who it's shared with, so you couldn't go to them and say, unsubscribe me or take me off your database. So I think this idea that once you've shared it once voluntarily, you therefore, it's sort of forever lose the chance to say anything. I think that's really critical to this idea of expectations of privacy as well. And I think the other thing is, in the same way that we dealt with it in the sort of copyright sense, that, back in the old days when stuff was on the internet, therefore it must be free, right? It's free, there's no money involved, therefore it must be free to use and I can copy it and do whatever I want with it. Right? We fought that battle from an intellectual property point of view to say, just because it's online doesn't make it free to use. All the work that Richard Stallman and other people did. But I think we need to have exactly that same discussion now, saying just because the data's out there doesn't mean you can use it. Just because I voluntarily post images or text in a context that I'm happy with, you can't pull it out of that context and then use the data to mine it. I might join a date like the issue we had with OkCupid recently, where a lot of people revealed really sensitive information about their sexual preferences, about what kind of movies they like, which is not as sensitive, but a lot of really invasive information, which they thought they were happy to do to make that trade-off because they thought it was in a dating app where it would be kept private. Somebody scrapes all of this data without checking with OkCupid, without checking with users, and writes a research study and publishes it on the internet without anonymizing people. Like that's super creepy, right? But that person never expected it would come out there. So I think again, in terms of expectations, I think a really good way to look at it is in terms of boundary management, but also context. So we're taking it out of the context in which we trusted and shared it's leaking onwards. And I think the last point I would make is when we think of data as something positive, if data is currency, data is the new oil, data is the new lithium, data is the new whatever, I think that's really valuable because if you see value in it, people want to monetize it. I think if you start saying data is toxic, data is like an environmental hazard, data is dangerous, data is a liability, because I think the fact is the more data people collect, the more they're liable for things going wrong, for data breaches, for hacking attempts, for security risks. So I think if we show that only collect what you need, because anything more than that imposes a liability on the organization and a cost, right, to keeping it safe and secure, and the reputational loss that can occur when things get hacked and breached, I think that's a really useful way to go forward, showing that data can be really useful, but it can also be a hazard in the wrong hands.
Thank you very much, Malavika. I just would like to point out, indeed, if the data is the new oil, it's a strange oil because it's not even text, if you know what I mean. And we don't really own our data, just like I tried to point this out yesterday, because had we owned it, we would be very rich. And we're not very rich. It's the several internet content platforms that are super rich. So these are the ideas of the data ownership that Makoto was also saying that I think are really important, that just simply suggests and points to the ideas to whom this power belongs and who controls this, these procedures online, and how internet architecture actually implicates these human rights. And unless we really want to waste all our coffee break, which I'm not sure if people would like to do, if somebody feels a pressing need to ask the final question, I would invite to just give a round of applause to our panelists. And thank you all once again. I hope we will continue these discussions further. Thank you.